Bismillahirrahmanirrahim, students. I once again welcome you in the online class. And today we'll be starting another topic. The topic relates to Section 55 of the Transfer of Property Act, which relates to the rights and liabilities of the buyer and seller. As I told you, students, in my earlier class, I taught you the concept of sale, which is a recognized modes of transfer. Then we discussed the concept of sale, the requirements of a valid sale, what is an agreement of sale, differences between sale and agreement of sale. Today we are starting Section 55 regarding rights and liabilities of the buyer and seller. Now Section 55 pertains to the various rights which the seller has or enjoys as against the buyer, vis-a-vis his obligations against the buyer. Likewise, what rights the buyer has against the seller, and what liabilities or obligations the buyer has against the seller. Section 55 can be divided into two portions. Portion A, seller's liabilities before completion of sale, and seller's liabilities after completion of sale. Likewise, buyer's liabilities before completion of sale and buyer's right before completion of sale. So first of all, we'll be starting regarding buyer's liability before completion of sale. What do you mean by buyer's liabilities before completion of sale? It refers to what are the liabilities of the buyers before completion of the sale. Yani the sale has not taken place in a complete manner. Am I with you? The sale has not taken place in a complete manner. No sale deed has been effected. But law postulates what are the liabilities of the buyer. Likewise, Section 55 also says what are the seller's liability before completion of the sale. The sale has not taken place finally. It's a preliminary. Parties are agreeing or entering into the contract of sale, or they have entered into a preliminary agreement of sale. Now, what are the obligations of the seller before completion of the sale? We will be doing in piecemeal manner. First of all, I'll be taking you the seller's liability before completion of the sale. Section 55 relates, first of all, subsection 1A of Section 55 say it is the liability of the seller to disclose material defects. It is the liability of the seller to disclose material defects. Yes. The law enjoins a liability, an obligation upon a seller that at the time of entering into the contract of sale, he must disclose material defects which are present either in the property or in the title of the seller to the property, which the seller knows and the buyer do not know. About such a defect which the seller is only aware but not the buyer, and the buyer could not have discovered the defect with that ordinary care. Am I with you, students? It is necessary that the defect must be a material defect. That is to say, a major defect which goes to the very, very root of that property. If the buyer would have known, he would have not have entered into the contract of purchase of that property. There may be certain major defects in the property. आप ये कहेंगे सर कैसा? The defects in the title may be encumbrance on the property, charge on the property is already mortgaged, or there are certain restrictive covenants attached to the property. Certain restraints are there in the transferring of the property, which the seller is only aware of it and the buyer is not aware. And at the time of entering into the contract, the seller does not disclose it to the buyer. Under such circumstances, there is a breach on the part of the buyer and the contract can be terminated or can be set aside by the court on the ground that it was an obligation of the seller to have disclosed the factor of that major defect in the property or in the title in the property, which the seller himself knew and the buyer was not aware. So the laws subsection 1 clause A of section 5 puts an obligation, or it is a liability of the seller to disclose the material defects which are existing or which existed in the property at the time of entering into the contract of sale. In the words of Tyndall Chief Justice in one of the cases of Flight versus Booth, he has observed this concept of material defect and seller's duty of disclosure in the following words. The material defect must be of such a nature that it might be reasonably supposed that if the buyer had been aware of it, he might not have entered into the contract. For he would be getting something different for what he contracted to buy. In other words, if the buyer knew and the seller would have disclosed him at the time of that entering into the contract that this property is suffering from such and such defect, the buyer would now not have entered into this such contract. Under such circumstances, it is an obligation, it is a duty of the seller to disclose the material defect in the property. This is the very first obligation as postulated under subsection 1A of section 55. The second obligation, students, which the law imposes upon the seller is under subsection 1B of section 55, that it is a duty of the seller to produce the title deeds for inspection. Yes. That at the time of entering into the contract, if the purchaser demands from the seller that he wants to see the title documents, he wants to inspect the title documents of the property, it is a bounden duty or the liability or the obligation of the seller to place it before him so that he may be able to satisfy himself with regard to the title of the property. He cannot avoid it. The seller is bound to bring all the documents of title relating to the property in his possession or power for the inspection of the property. In other words, it can be termed as the seller is bound to produce all the title documents demanded by the buyer for his examination. The buyer should examine it carefully, all the documents relating to the property for his own protection, because the law enjoins caveat emptor principle, let the buyer beware. He has to satisfy whether he is getting the property in a clear manner or not. The documents must be examined either at the seller's place or at the buyer's place, subject to the convenience of the parties. If the buyer does not demand any such document, the seller is under no obligation or duty to produce them. Where the buyer does not examine the title deeds, the court will presume that he is satisfied with the authority and title of the buyer. So students, the second clause which postulates or casts an obligation upon the seller is to produce the title deeds for inspection. He has to produce certain title deeds for inspection at the request of the purchaser. It is an obligation that he has to fulfill his duty, that if the purchaser requests that please produce the title deeds and I would like to satisfy myself by going through it, the seller cannot avoid it. A liability is enjoined under section 55 subclause B1. Am I with you? Then the third liability or the third obligation of the seller is contained in subclause 1C of section 55. Am I with you? And what does it say? It is a liability of the seller to answer all the questions relating to the title of the property. Now what does it say? It is a liability of the seller. Am I with you? That if the buyer put query or inquiries, and if he wants to satisfy himself further by asking certain questions in order to satisfy with regard to the validity of the transaction, the seller cannot avoid it. It is the duty of the seller. Am I with you? It is the duty of the seller to answer the queries of the buyer subject to his satisfaction. Or the seller says, my advocates need further clarification. Please clarify the title of the documents, or further clarify that prior to this, with whom the title of the document lie, it is not clearly mentioned in the recitals of that agreement or the sale deed which you have earlier in your favor. So the law enjoins a duty, or the law enjoins an obligation upon the seller that he should answer the queries, he should answer the inquiries, am I with you, questions which are put forth by the purchaser or the buyer. The seller is, in other words, it can be termed as the seller is bound to answer to the best of his information all the relevant questions put to him by the buyer in respect of the property or its title. Since the buyer is getting the ownership of the property, he is getting the ownership of the property, it is in his interest that he must fully satisfy himself about the ownership rights of the seller and his authority to make the transfer. That's why mere inspection of the title deed sometimes is not sufficient. If there are some doubts, the buyer may ask them, and the seller must answer them to the satisfaction of the buyer. So the legislature in its own wisdom has inserted this clause under the section 55 that when, in order to satisfy himself, the purchaser can put the queries or questions to the buyer, to the seller, and it is a bounden duty of the seller to answer or to clarify such inquiries to the satisfaction of the buyer. Am I with you? Then come another obligation upon the seller, and that is also contained in section 55 clause 1d, to execute a proper conveyance. To execute a proper conveyance. Yes, it is his duty. It is the duty of the seller to execute a proper conveyance of the payment or tender of the amount due in respect of the price. मैंने आपको बताया था कि साहब, in a transaction of sale, the price is predetermined. Without predetermination of the price, the transaction cannot go forward. The price may be paid, partly paid, or promised to be paid. Am I with you? आपको सारे मैंने आपको शुरू में बता दिए थे. Now, what does this clause postulate? It says, conveyance means the transfer of ownership. This is done by signing of the sale deed or putting the thumb impression on the sale deed by the seller if he is an illiterate person. The duties of both the seller and the buyer under this clause are reciprocal. give and take. When the buyer makes the payment, the seller has to execute the conveyance. It is on a proper place and at a proper time. It must be at a proper place and it must be at a proper time, as mutually agreed between the parties. But what is the proper place and time? It has not been specifically spelled out in the provision of section 55. The parties may agree, subject to their convenience, as mentioned in the agreement. The proper place and time may be decided by the parties by the mutual agreement. However, the conveyance must be made within a reasonable time. Reasonable time means within reasonable time after tender of the price. In case there is no stipulation fixing the time of execution and the seller makes unreasonable delay in executing conveyance, the proper course is to give notice, making the time the essence of the contract. As I told you, even in the specifically fact that in transaction of sale of immovable property, time is never the essence of the contract, but the parties can make the time essence of the contract by entering or stipulating a clear term in the agreement or the contract itself. So what is the fourth obligation? The fourth obligation upon the seller is to execute a proper conveyance, that is to say, to execute a proper transfer subject to the payment of the sale consideration by the purchaser. Another obligation which is contained under section 55 and which casts a liability or a duty upon a seller before completion of the sale is to take care of the property in title deeds. Yes, because at the time of entering into the contract of sale or agreement of sale, the seller is not completely ousted from his ownership right. He is still the owner. He has not yet executed the sale deed. Am I with you? What are we studying? We are studying seller's liability before completion of the sale. The sale is not yet completed. An agreement of sale has been executed, a preliminary agreement or an initial agreement has been executed, and the law casts a duty. Okay, no, seller sir, it is your duty to take proper care of the property. You must see that the date in between, from the date of execution of the sale till the date of delivery of the possession of that property to the buyer or execution of the sale deed or the conveyance deed in his favor, you must take the care of the property as a custodian of the property, because an interest of the buyer has been created by entering into the agreement of sale with him. So, and you must take care of the proper title of the property. You must take care in a shape that you are acting as the custodian of that property, because the party, the purchaser, has paid a particular amount of earnest money, or he has paid substantial amount of earnest money, and you are acting as a custodian from the date of that agreement of sale till the date of the conveyance deed or execution of the sale deed, provided the purchaser has fulfilled his part of the contract and is still fulfilling the remaining part of the terms and conditions of the contract. Here, section 55 1b 1e postulates that it casts an obligation upon the seller to take care of the property and the title deeds. Now, how they have mentioned or they have elaborated this concept can be elaborated that this clause say that between the date of the contract of the sale and delivery of the property, the seller is bound to take care, as much care of the property and all the documents relating to the title which are in his possession, as an owner of ordinary prudence, am I with you, would have taken such property and documents. Now, this clause further lays down the duty of the seller between the contract of sale and delivery of the property. अभी मैंने आपको बताया था. Within this time, the property remains with the seller, but only in the capacity of a trust, as a matter of trust for the buyer. He holds the property as a trustee for the buyer because he has already executed the conveyance, only the delivery of the property is to be made. Under such circumstances, the seller has to preserve the property as well as the title deeds. The extent of care which is required by this clause is such a care as an owner of ordinary prudence, intelligence would have taken of his own property. Ordinary man of ordinary intelligence would have taken his own property. This duty continues till the possession of the property is given to the buyer. If the seller fails in performing his duty, he will have to compensate the buyer for the loss occasioned to him. So he is acting as a trustee of, or as a custodian of that property on behalf of the buyer, because yet the possession is to be given in favor of the purchaser. So this is another obligation which is contained in section 55, and it's cast a liability upon a seller before completion of the sale. Last not the least point before we conclude this clause, the last liability of the seller before completion of the sale is to make or to pay outgoing charges. Yes, as I told you, student, that by entering into an agreement of sale, the seller is not divested of his ownership. If the parties are not agreed otherwise, as per the terms of the contract, section 55, clause 1G postulates and casts a duty, an obligation upon the seller that he is bound to pay all public charges and rents accrued due in respect of that property. He is still the owner. Am I with you? He has to pay the utility charges, he has to pay the betterment charges, he has to pay the tax various tax and liabilities outgoing, sewerage charges, water charges, etc., which are accrued due in respect of the property up to the date of sale, the interest thereon or on encumbrances on the property due, except where the property is sold subject to encumbrances, to discharge all encumbrances on the property then existed. Before the completion of the sale, the seller has to pay, by virtue of this clause, all the outstanding on the property, all the public charges like rent, revenue, taxes, etc., unless there is a contrary intention. The parties otherwise agree. No, it is a duty of the buyer to pay. If the parties sometime insert a clause, no, it is a duty of the buyer to pay, then it will not be applicable. If the clause is silent, there is no such clause, then by virtue of section 55(1)(g), am I with you? It is a liability or it is a duty of the seller that he should pay all the outgoing charges. In other words, it can be termed as where the seller, it is a duty of the seller that up to the date of the sale that he should pay all the charges, interest, rent and utility public overdues, so that at the time of filing conveyance no outstanding liability may be outstanding against the buyer. These are the various liabilities which are cast, or the obligations are there upon the seller before completion of the sale, which is contained in section 55, as I told you, subsection 1, A, B, C, D, E and G. I have bifurcated into two portions: seller's liabilities, buyer's liabilities before completion of sale. Seller's liabilities, buyer's liabilities after completion of sale. So आज हमने जो आउटलाइन पढ़ी है वो सिर्फ एक मुख्तसर सी छोटी सी हमने आउटलाइन पढ़ी है. This pertains to seller's liabilities before completion of the sale. Am I with you? And we have done under A B C D E F G headings. Am I with you? आज के लिए इतना काफ़ी है स्टूडेंट्स, फिर जब नेक्स्ट क्लास होगी तो वी कंटिन्यू।